Speaker today is Chad Moody, JD. Our program is underwritten by an educational grant through OSUMC Graduate Medical Education. A disclosure statement has been signed and is on file in the Graduate Medical Education Office. And our CME code for today is 2248. That's 2248. Chad has been practicing law with Rudolph and Todd since 2003. In the last 20 years, he has developed a multi-state practice and has successfully defended clients at trial in several states. His practice currently is devoted to the defense of healthcare providers, employment law, trucking defense, and medical staff and credentialing disputes. Prior to joining Rudolph and Todd, Chad served the state of Oklahoma as an assistant district attorney for Tulsa County, as a felony prosecutor, and as a director of crimes against children. Over the years, Chad has been asked and has served as a guest lecturer to various seminars on the topic of trucking law, the importance of correctly charting medical records, and reporting laws regarding child abuse. Chad also served as an adjunct professor of law at the University of Tulsa, teaching trial practice. He is a fellow of the American College of Trial Lawyers and an associate of the American Board of Trial Advocates. Please welcome a great friend to our profession, Mr. Chad Moody.
Thanks, Jim. Okay, is it working? Is the mic working? Okay, very good. Yeah, I think it is. Are we good? Okay. So it's interesting to me to start off that all of you have moved yourself to this side of the room. I think it's so you can be as far away from those who are going to be speaking as possible. So I'm going to wreck that for you and move over here in front of you. I was gonna do the whole Catholic Church thing that used to happen when I was a kid, when the priest would be like, okay, everybody in the back, come up to the front, but we're not gonna do that. Okay, so it's early. You guys are all residents, is that correct? Does that mean different years in residency? You're medical students.
Residents are back here.
The residents get to sit in the back of the bus, where the cool kids are. Medical students up here because you're nobodies yet. You think you're somebody's, but you're not yet back there, so it'll happen. Has anybody done the rotation through my firm? Are there any ER residents in here? So there's a group of fourth-year residents that over the years have come through my firm and done a 6-week rotation that are all ER residents, which is really interesting. And if you are an ER resident, you want to do that, talk to someone about it. I call it the eye-opening 6 weeks, where you get to come in and sort of see what we do and go to some depositions and maybe sit through remediation. I've had a couple of guys and gals that have sat through, come to trial with me when I happened to have been in trial when they were there. And it's an eye-opener because this part of your life hopefully will be non-existent, and at a very minimum will be something that only happens for a short period of time. But it's something that you probably didn't think about much when you decided I'm going to go to medical school and I want to be a doctor, which are all great things. But there is a distinct possibility that if you do this long enough, you're going to get sued. And there's also a very good possibility that you're going to get sued when you didn't do anything wrong. And you just need to accept the fact that that's not completely in your control. People that are as smart as you all are like to control as much of your life as you can, and you need to accept that this is something that you can't control completely. So I say all these things, and what we talk about today isn't to try to be Debbie Downer and to be this black cloud over your otherwise amazing experience learning and training to be a doctor. But I think it's something that you should talk about, and it's something that you should come to grips with and realize that if you do get sued, you're gonna make it. It's gonna be okay. It'll be 21 years at my firm in March. For me, I haven't lost anyone yet. No one has required emergency medical services in the course of their litigation. There has been frustration, there's been tears, there's been a lot of laughter, and there's been a lot of relief at the end of it. So all of those things will happen, but what I wanted to talk about today is, what do you do? Okay, what are the nuts and bolts of it? You may have thought, somewhat abstractly, okay, there's this thing, there's lawsuits out there, and it may happen to me, but let's talk about nuts and bolts, what happens, okay? So there's really gonna be two situations, one, or really there's two options that are gonna happen to you. When you get out of residency and you go take a job, you're either gonna be employed by a healthcare facility, whether it's a hospital or some other type of organization, or you're gonna be out on your own where you're paying for your own malpractice coverage. If you work at a hospital, almost every single doctor that I've ever worked with that's an employee of a medical center, the medical center provides their malpractice coverage. So the reason why I bring that up is there's really two paths that happen, okay? You get served with a lawsuit. One of your patients is unhappy. They decide they're gonna go get a lawyer. That lawyer draws up a lawsuit and they find someone to come and serve you. Okay, so they put it in your hands. What do? Besides say, oh crap, here it goes. Okay, so you should have been instructed what to do by either your malpractice carrier or by your employer. So let's start with your employer. Let's say that you come out of law school and you take a job at a hospital, and part of your onboarding at whatever facility it is, I'm sure they're going to run through with you. Here's what happens if you get sued. You let someone at risk management know, you let someone at administration know, you let whoever it is, your boss know. I'm sure that they're going to tell you that. If they don't, that's what you do. You let someone know. So why do you do that? One, it's probably part of a contract that you will have signed as an employment contract that you are to let them know, and that you are to cooperate with whoever it is that they assign to work with you. If it's me or my firm, you will be told this is going to be your lawyer. They will contact you. We'll come have a meeting. We'll start to get to work on it. Scenario two is you go and you sign on with the group and you provide your own malpractice coverage. And let's just say that you're like the majority of the people in the state and you're insured by Medical Protective, which used to be PLICO before any of you started medical training. So when you have medical malpractice coverage that you're paying for, what you have is a contract. You have a contract with an insurance company, and each side has certain requirements that they are responsible for. The medical malpractice insurance company promises you that if you pay your premium, they're going to provide you with a certain amount of coverage. Normally in Oklahoma, it's $1 million in coverage for each individual event, or $3 million in the aggregate. And what that means generally is that we're going to pay you for, you have up to $1 million in coverage if you are found negligent for patient X, but after patient D, the third one, if you get over 3 million, then you're kind of on your own. Okay, I've never seen that happen in my life where someone got sued so many times that they were out of aggregate coverage. If you're that bad, generally you don't make it out of its piece and you don't get to that point. So, but that will be part of your contract. And one of the things they'll tell you is you pay your premium and we'll provide you coverage. Your additional obligations are to let your carrier know immediately when you've been sued. And there are ramifications if you don't do that. If you don't let them know, then they have in that contract provisions where they can say, you know what, we're not going to provide you coverage because you didn't let us know and we didn't have time to prepare. Anyway, that's not going to happen to you all because you're going to be smart about it. And most people, when they get sued, do the, oh crap, I don't like this, I need help. They call their carrier calls my firm or some other firm in Tulsa or in Oklahoma or wherever you are, and you get assigned a lawyer. Okay, so those are your responsibilities. You have responsibilities as a party to that contract, and it is a contract. If they don't live up to their end of it, then you have options to go against them. If you don't live up to your end of it, then they can do things like decide not to provide you coverage. None of that's going to happen though. You're going to do the right thing and you're going to let them know. Generally, these companies, Medical Protective in particular, there's a group of lawyers in the state. We've all been doing this for a long time. I could give you probably 5 or 6 firms and tell you these are the firms that will represent you if you get sued 99% of the time. So I know all of them, everybody knows what they're doing. You're going to get a good lawyer to represent you if it happens here in Oklahoma. And generally everywhere else also. It's a kind of a specialized niche. People sort of do this. I do some other things also, but there's not just everybody that gets thrown in with medical malpractice cases. There's some things you really need to learn and some nuances that are important. Okay, so now you've been sued. You've let the people know who need to know, who are going to help you find a lawyer and work through the process. So what are some other things you need to do? Shut your mouth, okay? You can talk to me or your lawyer and it's privileged, okay? That means that you can come in and tell me the good, the bad, and the ugly, and that's what I want to hear. I want to hear it now instead of later on when you're under oath for the first time and I go, oh, that might have been nice to know 6 months ago when we first talked about this. If your lawyer's there, you're protected. And if your lawyer's there and other people are in the room that shouldn't be in the room, your lawyer's going to tell you, we're not going to talk about this while this person's in the room, and it's going to politely ask that person to get the hell out of the room so that I can talk to my client. Okay? Things not to do. Don't send a big text message to your best friend saying how awful this is, and you knew this was going to be a bad deal, and you knew you made a mistake that night, and this patient's wife is such a bitch, and I can't believe she did X, Y, and Z. Don't do that, okay? Just don't, because that is discoverable. If you say that to me, it goes to the grave with me. Say it to your best friend, or your girlfriend, or your husband, or your wife. There's an argument that that's discoverable. Okay, so don't do it. You have a lot of other great things going in your life other than your lawsuit. Talk about those things. Talk about the lawsuit with me. Okay? If you are employed at a hospital and your administration or your risk manager or whatever says, oh my God, you've been sued, let's bring everyone together and roundtable this thing. Now, there's a difference between a root cause analysis or a peer review situation and, oh my God, let's get everybody together and roundtable this thing. That is a bad idea because that thing is not protected. Again, a good lawyer and an honest witness, that will be revealed. Don't do it. Okay, don't do it. I have told people for years and years, don't do it. The other thing not to do, don't go run to the medical record. Especially don't go run to the medical record and change something. First of all, that'd be a bad thing. And if you're that dishonest, you need to think about your career path. Don't go do that. It's okay if you look at it. Some people will tell you, oh my God, don't look at the medical record because there's an audit trail and they can tell, well, you looked at it on this day and that's a year and a half after this patient left. Why'd you do that? I don't have a problem with telling them, well, you sued me, so I thought I would go back and start familiarizing myself with the record because I knew I was going to have to do that. I'm fine with that answer. A lot of people aren't. So until you talk to your lawyer or the person who's going to be helping you with your case, don't go get into the electronic medical record. Don't go make a timeline. Oh my God, I need to get all of these facts straight in my mind. Don't do that. Okay, if your lawyer, after you meet with your lawyer, if your lawyer said, I would like for you to create this for me, now it's protected. Now you've done it at the request of your lawyer and it's work product. If you do it on your own, it's just something that they get to look at later. Okay, so all of these things, I don't say these things to scare you. And 99% of the things that you would write are probably objective and probably aren't much different than the medical record. But it's really hard in the heat of the moment when you're emotional not to put things in there that aren't just objective. Okay, and we avoid all of these things by not doing it. Okay, so you're gonna want to talk about it. You're gonna want to vent about it. You're gonna want to cry about it. Whatever it is, do that with your lawyer. Okay, it's the one thing that that the lawyer really gives you that no one else is, and that's protection. They call us attorneys and counselors at law. And there's a big piece to the counseling of this. And don't feel bad about needing to go in there and vent to your lawyer about, oh my God, does this mean that I'm gonna have to file bankruptcy? What does this mean for my family? These are questions that can be answered. And no, it doesn't mean, okay, you have coverage for a reason. Mistakes get made, okay? Accidents happen. There are times that patients' families need to be compensated. That's part of it. You're not expected to be perfect. If you were, there would not be a medical malpractice insurance industry. So all of you are going to feel bad if you get sued. All of you are going to feel bad if you have to settle a case or if you go to trial and a judgment is entered against you. Get past it. It happens. I know you're trying your best. I know you're not in here for any other reason other than you decided you wanted to help. Okay, that will serve you well. Don't let it eat you up if you've been sued. Okay? Don't freak out. This is not something that's going to be resolved in the next week, 2 weeks, 4 weeks, 6 weeks. You all are kind of type A type people. And you're gonna I want this done now. It's a time in your life where you're gonna have so little control that it's going to drive you crazy. If your lawyer's smart, he's going to tell you this is a marathon, it's not a sprint. What I tell every doctor that I sit down with, I don't care if they've been out for 2 years or 22 years. I tell them this: we have a long way to go. I will let you know when I need something from you. When I need to meet with you, I'd like for you to be available and give me the time that I need. Other than that, I'm gonna leave you alone. And when I leave you alone, I want you to go be a doctor. I want you to go be a husband, go be a father, go be a wife, go be a mother, whatever it is. Go live your life. Let me worry about this. Okay? So it's real easy for me to say. Some people, some doctors deal with this better than others. And it's not a reflection on your character. It's just some folks are a little bit wound different than others. That's okay. What you're gonna find out is that some lawsuits go faster than others, but none of them are extremely fast. There are cases that need to be resolved quickly, and sometimes that happens. There are other cases that last for years before they're resolved. I have a lawsuit right now that I'm just trying to conclude that was care from 2001. And this lawsuit was filed the day before a child's 19th birthday. It's the absolute end of when it can be filed. So is that the end of the world? No, it's not. You deal with it. It's good and bad for everyone. I have other ones that get done in, maybe a year and a half. That's okay. If it goes to trial, probably looking at 3 years before it's finished. So when I say take a deep breath and go live your case, that's what I mean. Okay, so why does it take that long? There's a myriad of reasons. Some of them are completely out of our control. For instance, who's familiar with the Supreme Court decision called McGirt? Anybody heard of that? You've heard of McGirt? So what McGirt said was, and I'll tell you why this applies to our world. McGirt was a Supreme Court decision that decided that the state of Oklahoma cannot prosecute Native Americans for crimes that are committed on the reservation. Which Oklahoma, especially eastern Oklahoma, is largely still a reservation because Congress never de-established the Creek, Cherokee, Seminole, Choctaw, Chickasaw reservations. So what it did was, now the federal government or the tribes can only prosecute Native Americans on that land. So what did that do? That meant federal court now was completely devoid of civil lawsuits. So if you were sued in federal court, that meant that your case is now going to wait behind all of these criminal cases that now have to be tried because folks are in custody or whatever it is. So that decision in Supreme Court meant that if you get sued in federal court, you're looking at 3 or 4 years before you can even get a trial date. Okay, now the majority of cases are filed in state court, but you run into the same thing in state court. I have a pretrial conference that's coming up next month, and I anticipate that I'm going to get a trial setting from February of 2024. My trial will probably be set in the spring of 2025. Okay, and that's just a matter of there's backlog. It's also a matter of medical malpractice cases require expert witnesses. So it's not like a car wreck where each driver testifies and a doctor comes in and or a chiropractor comes in and says, yeah, her neck's hurt. And someone comes in and says, here's how messed up the car is, and it's over in a day and a half. These cases involve usually 2 or more experts. They involve family members that come in and testify about what the nurses say, what the doctor said. The patient who testifies, the physician testifies, other physicians who were involved in the care testify. I think the shortest medical malpractice case I've ever tried was 5 days, and the longest was just past 5 weeks. So it all depends. The one that was 5 weeks had 19 experts. The one that was 5 days had 2. So it all depends on where you are and what the case, what's going on with the case. So those are the things we really can't control. But here's what happens in the beginning. So you get a lawsuit, and the first thing the lawyer has to do is file an answer, which is the lawyer comes in and denies all of the allegations that say you did bad things. No, we didn't do any of those things. So we get an answer on file. Then each side trades written questions. Okay, they're called interrogatories. You can also send requests for admissions, and you can send requests for production of documents. All of those three things happen on each side. We will send those to the plaintiff or the patient's lawyers for them to answer, and they will send those to us for you all to answer. Okay, so a request for admission might be something to the effect of admit that you are not making a claim for lost wages. Okay, you're trying to get some stipulations to sort of narrow down the allegations and the things about the lawsuit that are going to have to be contended with. So if you have a retired person that's been retired for 5 years that comes to the hospital and something goes wrong with and they file a lawsuit, they're not going to have a lost wage claim. They're not going to have a lost earning capacity claim because they're retired. If you have a 35-year-old accountant in the same situation, then you're probably going to have a lost wage claim. But you're trying to narrow those things down. So those are requests for admissions. Interrogatories would be questions where they might ask, please give us all of the reasons why you have sued Dr. Smith. Please identify the witnesses who were present in the hospital during the admission. So you're trying to narrow down who do I need to focus on in these preliminary portions of the case where you're exchanging written questions. So after that, after each side does that, then you start taking depositions, which is sworn testimony. So from the defense side, we will take the plaintiff's deposition or the patient if they are still living. If they're not, then you take their family members or person that's bringing their lawsuit on behalf of their estate. And there's nothing magical about a plaintiff's deposition. It's tell me what happened, tell me what you remember. Sometimes they take 2 hours, sometimes they take 6. Who all was there with you? Tell me about, you dig into their past medical history, you dig into their work history. It's basically your chance to interview them. Okay, so we do that for the plaintiff and their family members and any other fact witnesses they may have. And they will ask for the doctor's deposition. They'll take probably nurses that are involved in the care and ask them the same thing. What do you remember about this day? Ask them things that are beyond the medical record. Do you remember any conversations that you had with anyone about the care of the patient beyond what's in the medical record? The other thing that we'll be doing along these same lines after we get information back from the written questions is to go gather prior medical records. What went on with this patient before they came to the hospital? I've yet to have a case in my life where I didn't learn something that was relevant about the case from the prior medical history, because they may not have told you that, oh, yeah, he had back surgery 14 years ago. That would have been nice to know since you're complaining about back pain. I've got a case right now that's an orthopedic case where this patient is complaining of this horrible pain now that they have after they had surgery with my client. Well, I got his prior medical history, and it turns out that he's been taking 4 Percocets a day for 9 years. So you probably had some pain before you came to see my client. Aren't things that they're just going to offer up to you. You have to go dig them out. So that's part of what's going on. You're trying to dig out all the information that you can about these people. Now, I may be jaded. Well, let's just be honest. I am jaded. Okay? I don't trust plaintiffs and I don't trust their lawyers because this is about money. All right. Now, you all are caring people, and you got into this because you wanted to help people. You have compassion. You want your patients to get better. You're going to feel bad. There's rare exceptions. You're going to feel bad that your patient is unhappy to the point that they've sued you. And you might let yourself get drawn into this feeling of, oh my God, this lawyer is really championing the cause of this patient or this family. Okay? Get that out of your mind. This is about money. Okay? It's a business. Whenever this case is over, if it's dismissed or settled, or there's a verdict at trial, whenever that financial transaction is done between that patient and their lawyer, their relationship is over. They're not going to send them birthday cards and Christmas cards. They're not going to check in on them. And that's fine. It's a business. But don't let yourself get sucked into thinking, oh my God, look what a wonderful thing these lawyers are doing for these people. It's about money. Okay? And a lot of them don't care about the truth. This is not a truth-finding mission. You will hear people say, oh no, the law and trials are about finding the truth. No, they're not. Okay, they are about making sure that that plaintiff's lawyer doesn't turn this into something that it's not. Okay, they don't care if something that they say about you or the care that you provided is completely true. They care about if they can convince 12 people to believe what they want them to believe. Okay, so yes, I am jaded. I've been doing this too long. I've seen too many of this. Now, are all plaintiffs lawyers like that? No. I have plaintiffs lawyers that are very good friends. I have others that I would not pull over and help them put their car out if it was on fire because they're awful. To be honest with you. And if you have one of those, your lawyer will tell you this is awful. I like it when I get cases against those guys because there's no conflict about I'm trying to rip their arms off and beat them up that. Okay. There are others for whom it is a more professional experience where the truth finding mission is really there and they're going to be honest with each other. That's not everyone. Okay, so how are you involved in this? How am I going to keep my practice going? How am I going to take care of my family during these awful times of the lawsuit? Here's how you're going to do it. When we get written discovery in, I'm going to come to you and say, okay, we're going to answer these. I need your help with these things. Then I'm going to leave you alone. When it comes time for your deposition, the deposition is the second most important thing that happens in the case, except for the trial. Okay? You will spend more time with me in the deposition, getting ready for the deposition, than you will at any other time in the case, except for the trial. I'm going to teach you how to testify. That doesn't mean I'm going to teach you what the truth is. You know what the truth is, and we're always going to tell the truth. I don't care how awful these plaintiffs' lawyers are, we're going to tell the truth. Your license and my license aren't worth it. And you have insurance for a reason, and if it means that we need to settle a case, then that's what we're going to do. But we're going to tell the truth. Okay, so I'm going to spend time with you. I'm going to teach you the sneaky lawyer tricks. I'm better at them than they are, and we're going to talk about them. I'm going to teach you how to avoid getting yourself painted into a corner when you're in your deposition and going, oh crap, how'd I get here? There's ways that we as lawyers make you say things we want you to say. I'm going to teach you how to not do that. You're all smart. It's just going to be a matter of me telling you this is what they're trying to do, and you going, oh yeah, that's sneaky, well, I can avoid that. We're going to talk about hypotheticals. Talk about how you avoid answering hypothetical questions that they can then turn around later and use against you when they try to apply those same scenarios to the fact pattern in our case. Okay, so all of this time, it's going to take time. We're going to meet whenever you're available, whether it's before work, after work, at lunch, on weekends, whatever it is. We'll get ready. You're going to tell yourself after your deposition, probably Chad was harder on me than they were. It's the only way you get ready. Okay, so we're going to spend that time. You're going to be deposed. At the end of that, you're going to want to go have a drink or two, and then you're going to be done again for a while. I'm going to still be working. We're going to go take expert depositions with the experts that we find to defend you. We're going to go take plaintiff's experts. And then when we get to trial, then we'll re-engage again. And that week before trial, we'll spend some time together. That weekend before trial on Saturday, we'll spend a good part of the day together talking about here's where this is headed, refreshing you with what's going on. And then that Sunday before trial, I'm going to tell you to go home. Relax, spend time with your family, come back Monday, and you're going to spend the whole week in the courtroom with me. And you'll know far out when the trial's set. Like I mentioned earlier, you'll probably know a year out. Here's when our trial is, and you're going to need to take probably that Thursday and Friday before the week of trial off, and that whole next week, or 2 weeks, or 3 weeks, however long the trial is going to take. You're going to be sitting at the table with me. And it's going to be a stressful thing for you, especially at the beginning. And then you're going to kind of get in the groove and go, okay, there's something empowering about this for me. I get to take the stand finally and defend myself in front of 12 people who are going to make a decision for me. Okay, I have put every kind of doctor I can imagine on the stand. When I was a DA, I think the youngest child I put on the stand was 4. Come in and testify what some awful thing that mom's boyfriend did to her. Okay, if that girl can take the stand, you all can take the stand. You're going to be fine. Okay, I'm going to get you ready. You're going to understand it. And for the first time, you're going to have people who are going to look at you and say, you know what, I like my doctor and I like what doctors do. And if they trust you and they think that you're being honest with them, you're going to go be a long way toward winning your case. Okay, one of the things that we'll talk about more than any when we're getting ready to be deposed is I want you to think about that jury, even when you're giving your deposition, because that testimony can be read to them in trial. But I want you to think about what the goal is with that jury. And what I like for them to say, and Dr. Jenny here is my doctor. Full disclosure, I'll give you my PHI. She's been my doctor for a long time. If you need an example of how to be a doctor, that's it. She's my parents' doctor. She's my wife's doctor. She's my wife's parents' doctor. This is our doctor. Kind of like the team mom for my family. But what I want is for that jury to feel about you like I feel about Dr. Jenny. Okay, I want them to sit in that box and say, I would be okay with that doctor caring for me or my family. If that jury thinks that, we win. Because they're going to forgive you even if you did something that wasn't completely right. And when I say we win, we may not win completely, but they're never going to hammer you. They're never going to come in and say, I need to punish that person, because they're going to say, you know what, that's a good doctor. And I know they did their best. And that's important in these things. But chances are we're going to win. And they're going to say, you know what, it's okay. No one expects that medical care is going to be perfect. But what they do expect for you is that you're going to be honest with them and that you're going to do your level best to do everything you can. Yeah. What you swore you'd do anyway, right? Do no harm. Come in and help people. That's what you wanted to do. If you do that, even if you do get sued, you're a long way toward being okay. Now, what are some of the things that you can do that are really bad? Okay, social media, really bad. Okay, if you have your phone with you, who takes their phone out when they care for patients? Not judging, raise your hand, you're all lying if you say you don't have your phone with you, you do. Okay, don't like something on Facebook, even if you're in between rooms. If you're on shift, don't do it. Don't like something on Instagram, I'm old. Those are the only two that I know how to use. I don't do the Twitter thing. The only reason I know about TikTok is because it's the Chinese that are trying to reprogram my children. I don't do that. But every time you do that, you're making it a timestamp. Hey, this is a real story. I had a nurse in a case in another part of the state that I truly believed her when she said that she was not on her phone when this bad thing happened to the patient. But she was in between rooms. She had been in that patient's room. He was walking down the hall to go to another patient's room, opened up Facebook, liked some pictures from a friend of hers. As soon as she was doing that, this patient codes. Okay, so they went on and got her Facebook, and you can go back and they looked and saw, well, this code happened at 1543. At 1543, you were liking pictures on Facebook. One had nothing to do with the other, but I don't think you want to defend that. No, I really wasn't. I had just left the room and I'm walking down the hall. Do it. I beg the nurses that I work with, leave your phone in your locker. Tell your kids, here's the number at the desk. Tell whoever it is that needs to get a hold of you, they can find you. So that little thing, it's a permanent timestamp on everything you're doing. It sort of tracks you. And I know you guys need your phone to text back and forth with each other and say, hey, I'm with patient X, here's what's going on. Or can you come down here? I know that's important. Make sure it's that. Okay? Stay away from putting things in electronics that you wouldn't want to say in front of a jury. Okay? Don't text your colleague, patient in 403 is such a bitch. Okay? She may be. Okay? If you need to tell your colleague that, tell them that. Don't put it in your phone. Okay? And it's important to vent those things. I don't like that person. She's not nice. Everything we do, she doesn't appreciate us. It's important to vent. Don't put it down in writing or put it in some electronic thing. It's saved forever. You never get rid of it. We can argue, we can fight about discovery on those things. You may even be right. But the only thing that matters is what that person in the black dress decides. That judge decides it comes in, it's in. We can appeal it, and then we've got black dresses in Oklahoma City that may make the same decision or a different decision. We don't know. We avoid all that by not doing it. Okay. So what happens to you if you have a lawsuit and you have to settle it? Okay. And it may happen to you. I hope it doesn't, but it may. I've settled a lot of lawsuits for doctors that I would have no problem caring for me or anyone in my family. It happens. So what happens to you? Does anyone know what the National Practitioner Database is? You heard about that yet? See some nodding. This is the most uninvolved crowd of my entire life. I'm getting no hands, nothing. So the data bank is this. It's like a big repository of information about doctors and settlements and lawsuits and those types of things. And the reason why it's important is because it's a tracking system. And I never saw anything about it that made me realize how important it was until a lawsuit that happened in the last 8 or 10 years. There's a doctor in Louisiana who was awful. This guy was committing malpractice like you guys go to the grocery store. I mean, just hurting people constantly. So the hospital in Louisiana says, okay, we're going to settle all these lawsuits, and we just need you to get on out of here. So they don't report him to the data bank. And what reporting to the data bank means that if you have a verdict against you, or if you settle a lawsuit, the hospital or your insurance company has to report it and say, okay, Dr. Smith had this settlement. It was a lap chole that went bad and the patient got septic and died, whatever it is, here's what was paid. That's in the data bank. Now, people can't go in there and look at it. It's privileged. But when you go apply for privileges at another hospital, they will query the data bank and they can find out, okay, here's what your history is. So they can make an informed decision about whether or not you're going to come on staff. Okay, now, if you get one report on your data bank, it doesn't mean that you're unhireable. If you get 12, you're probably unhireable. If you get 12, then you probably need to think about, maybe plumbing or something different. None of you are going to have plumbing. But this lawyer in Louisiana then leaves and goes to Washington State and doesn't tell them anything about what had gone on in Louisiana. And when they queried the data bank, Louisiana had not informed the data bank about all these settlements that they had made to get rid of these lawsuits and to get rid of this doctor. So Washington Hospital sees, hey, everything's clear. So they hire this guy and he goes up there and surprise, surprise, continues his practice and did some malpractice up there. Well, Washington gets busy and does an investigation and figures out that Louisiana had not reported to the data bank. So while Washington is trying to defend these lawsuits from patients that were brought against them, they file a lawsuit against Louisiana Hospital for a whole bunch of money and win a whole bunch of money because Louisiana didn't report. And they said rightly that if we had known that this guy was this guy, we never would have hired him. So that's why hospitals are really diligent about reporting those things. And it's important to know who's traveling between hospitals. Everybody wants their doctors to do well. Everybody wants their doctors to know kind of what your past is. So if you settle a lawsuit, you're going to be reported to the data bank. It happens to everyone that settles the lawsuit. It doesn't mean that you're going to be fired. It doesn't mean that you can't be hired somewhere else. It's just part of kind of the due diligence so that one hospital can know what someone else is doing. There have been a few situations in my 20 plus years where I've seen doctors who have too many cases. They've been sued too many times. They've had too many settlements. That is the outlier. And that is the way less than 1% of doctors. That is not going to be you. And these are, it's almost, there's a mental miswiring problem with a doctor that's that bad. And you have to be that bad for that to happen. So these are all things that you need to know about. These are all things that need to be in your mind and will probably be explained to you whenever you go try to work somewhere or get your file together to go apply for privileges somewhere else. And these are things that your lawyer will understand. Another piece to this that is different depending on where you work. If you are employed by a hospital and they are providing your malpractice coverage, they probably control whether your lawsuit can be settled or not. Okay, so what that means is you don't have consent. And consent means kind of the same thing, but a little bit different than you're thinking of in the medical setting. If you are, let's say you get finished with your residency and you go hang your shingle out, you're going to be Dr. Smith Family Practice, and you go buy a malpractice policy for medical protective, you probably have consent, which means that if you get sued, you can look at the insurance company and say, I don't give you consent to settle my lawsuit. It means they can't pay a nickel for you unless you sign a piece of paper that says, I'm okay with that. So there's pluses and minuses to that. If you work for the hospital and you don't have consent, you also don't have a premium. They're paying that for you. You're out on your own and you have consent, you're writing a check for that insurance policy. So generally, I will tell you that Your employer will take your feelings and what you want to happen in consideration, but at the end of the day, it's going to be their call, whether they settle your case or not. That's just the honest truth. Have cases been settled that I thought should have been settled in my career? Yes. Have cases not been settled that I thought should have been settled? Yes. Everybody has different opinions. I would say the vast majority of the time, no. Me as the lawyer generally is in agreement with the insurance company or the administration or risk management, at least about what the level of risk is for the case. The other thing you need to remember is that your lawyer is your lawyer. Okay, so when I represent, tell me what your name is, Dr. Joel. Joel here is going to be a Dr. Sid. And when I represent Joel, let's assume that Joel has gone out, and what kind of doctor are you going to be? Joel, you and I have met. I think we have. Joel, for today's purposes, is going to be an orthopedic surgeon. And he's going to leave here and go join a group, and he's going to have his own malpractice coverage. And a situation is going to happen where Joel didn't do anything wrong, but a crazy patient is going to sue him. And he's going to get assigned to me. And I'm going to remind Joel that I'm his lawyer. I'm not that insurance company's lawyer. Okay, they're paying me to represent you because you have a contract with them. And they said that part of that premium is going to be that they're going to hire me to represent you. Now, do they get to know what's going on with your case? Absolutely. But I represent you. I don't represent them. Okay, so it's something for you to remember too. And if your lawyer doesn't remember that and they think I work for Medical Protective or whatever that insurance company is, it's okay for you to remind them, you're my lawyer. Okay, now I will tell you almost without exception, everybody is in agreement in defending these lawsuits. Medical Protective understands that you're their insurer and their lawyer. There's a good relationship with everyone. And everybody works together, but it's important to remember that I'm Joel's lawyer. And you have a lawyer. I represent him. I don't represent Medical Protective. I work with Medical Protective, and I talk to Medical Protective probably more than I talk to Joel. But I represent Joel. Okay? And when you represent a hospital, there's not really that distinction because the hospital is paying into some fund to get insurance or whatever it is, but there's almost a more clear understanding of who you represent. I know I've thrown a ton of information at you. Hopefully some of you have known a lot of this already. If you have questions for me that you'd like to ask now, I'm happy to answer those. If it's not something that you want to ask in the middle of this room, I'll stick around and you can ask me whatever you like. Thanks for coming in and listening to me at 7 in the morning. I appreciate it. I hope that I don't meet any of you again. And I mean that because that'll either mean that you've been sued or I needed medical care. But I wish you all luck, and I'm glad that you've chosen the path that you have, and I'm glad that you've chosen OSU to go post.
Thank you, Chad. We hope you'll be able to come back soon.